Good morning, everybody. My name is Brian Gibbs, and today we will provide an overview of reporting requirements and compliance reviews for mortgage brokers licensed in South Carolina. This webinar is going to discuss what mortgage brokers are required to do, the South Carolina Department of Consumer Affairs compliance review process, and what we look for during compliance reviews. We will also talk about some previous issues and violations that we find. Okay, so who needs to be licensed as a mortgage broker in South Carolina? The Mortgage Broker Act requires that all businesses offering mortgage brokerage services, including loan correspondents, table funding, and independent contractors, loan processors, and underwriters. They have to file with the Department of Consumer Affairs using the NMLS. The current initial filing fee is $750. The renewal fee is $550. All checklists are found on the state licensing requirement page, which is easy to find from the NMLS Resource Center. South Carolina Mortgage Log. South Carolina law requires all mortgage brokers and mortgage lenders and servicers file a mortgage log each year directly with the state of South Carolina. Note that this log is separate from the mortgage call report filed with the nationwide multi-state licensing system and registry, which is the NMLS, and the HMDA data report that lenders file with the CFPB. The mortgage log submitted must be in the format determined by the South Carolina Department of Consumer Affairs and the Board of Financial Institutions. The Board of Financial Institutions instruct its licensees to file directly with the Department of Consumer Affairs. Who must file a South Carolina mortgage loan log? All licensed mortgage brokers must file pursuant to Code 405865, regardless of the number of loans originated made in 2023. The mortgage log data must include all data required by the South Carolina Code 405865. That includes South Carolina residential mortgage applications and loans, loans in process, closed loans, turn downs, denials, and withdrawals. We do ask third-party processors and underwriters to submit the statement of no activity, although they are exempt. Since they have the same license type as brokers, they are included in our reports. If you don't submit it, we'll end up sending you reminders. So it's going to save you some time and trouble if you just submit the log and say no activity. When is the South Carolina mortgage loan log due? A complete mortgage loan log must be submitted no later than March 31st of each year. And that's pursuant to the code 405865 for mortgage brokers and 3722-210 for mortgage lenders and servicers. A mortgage log with deficiencies will be sent back for corrections. Those corrections must be received by midnight on March the 31st. Is there a penalty for submitting the South Carolina mortgage loan log late? And yes, there is a fine of $100 per day for late or incomplete data submissions. So if you're 1 day late, it's $100. 10 days late, that's a $1,000 fine. 30 days late, it's a $3,000 fine. Now, how do you submit the South Carolina mortgage loan log? You will have to email the completed form to mortgagelog@scconsumer.gov with the file name in the following format. So you'll have the company NMLS number, the company name, and all licensees are required to correct and submit a correcting an amendment if any information contained in the original filing becomes inaccurate or incomplete in any material way. If you have questions about the South Carolina mortgage loan log data submission, refer to South Carolina mortgage loan instructions on our website at www.consumer.sc.gov/business resources licensing mortgage broker. After searching these instructions, state laws, and supplemental federal regulation information, licensees may contact the department by calling 803-734-4256, or you can email mortgagelog@scconsumer.gov. And if you have any questions, you can contact Curry Boyer Hawley. She's our licensing attorney. If you have any questions about the mortgage log, please feel free to reach out to her. So pursuant to South Carolina Code Section 405865A, a mortgage broker licensed pursuant to this chapter must maintain at their usual place of business, books, records, and all documents pertaining to the business conducted to enable the administrator to determine compliance with this chapter, and shall include a mortgage loan log. The mortgage loan log must be completed with information known at the time of the review by the administrator and must include loans in process, closed loans, turndowns, and denials. So most of the South Carolina mortgage broker compliance reviews will be coordinated using the CSBS statewide examination system, and that's also known as the SCS. So when a company has been selected for a mortgage broker compliance review, the contact person listed in the NMLS will receive an email from the SCS to register as a user to start the onboarding process. And once the company is onboarded, then they will be able to respond to any information requests with any state agencies. And right now, there are at least 50 state agencies that have adopted the SCS system. So once you are onboarded with one agency, then any of the state agencies will be able to contact you through the state examination system to do any exams. So we'll talk about what disclosures need to be kept in a closed loan file. And they are your initial loan application, you have a written cover letter, the signed South Carolina mortgage broker fee agreement, the initial loan estimate, all revised loan estimates with the change of circumstance, if applicable, the attorney insurance agent preference form, your list of attorneys, the initial closing disclosure for the borrower, your signed closing disclosure for the borrower, your home ownership counseling disclosure, your signed right to rescind, a broker fee check or wire transfer statement, and also the third-party processing invoice if applicable. In some instances, the department may request the complete loan file. So the initial loan application, which is also known as the 1003, you'll have the borrower's information will be on that, the financial information for the assets and liabilities, the financial information for the real estate. Section 4 is the loan and property information. Section 5 are your declarations. Section 6 are your acknowledgements and agreements. Section 7 talks about any military service, and Section 8 talks about your demographic information. And Section 9 is your loan originator information, and that section should be completed by the loan officer. Your written cover letter. So if you have to mail your disclosures and they're not going to be signed within 3 days of the application, we can use the date of the cover letter to meet the timing requirements. Next, we'll talk about your home ownership counseling disclosure. This disclosure is mandatory if you are originating a high-cost loan. So Section 372340 talks about high-cost loan, and the lender of a high-cost loan may not make a high-cost loan without first receiving a written certification from a counselor that is approved by the State Housing Finance and Development Authority that the borrower has received counseling on the advisability of the loan transaction and the appropriate loan for the department or for the borrower. The Department of Consumer Affairs shall specify the information that must be provided by the lender and reviewed by the consumer credit counselor. So next we'll talk about this is a state requirement, this document, the South Carolina Mortgage Broker Fee Agreement, Section 405875 states that within 3 business days of receipt of the application for a mortgage loan, the broker must provide the borrower with the fee agreement that discloses the total estimated charges to the borrower. A person may not earn, charge, or collect a mortgage broker fee unless the person meets the requirements of this chapter. All fees earned for the services rendered as a mortgage broker must be disclosed to the applicant by the mortgage broker as required by federal or state law. The mortgage broker fee agreement must be in writing and include the current name, address, telephone number of the mortgage broker's branch office, the account number, if there's any, the date of the agreement, the name of the borrower or the proposed borrower, signature of the borrower and the mortgage broker, the amount of any fees, and the nature of services provided to the borrower. A copy of the completed agreement must be provided to the borrower by the mortgage broker. And again, the only fee the broker or the only fee that should be disclosed on the mortgage broker fee agreement is the broker fee, and that is the fee that the broker is receiving either by lender paid compensation or borrower paid compensation. One other thing I will add on the fee agreement is anytime the agreement changes, is like if there's a DBA that is added or deleted, the company or branch address changes, the fee agreement must be amended to reflect the changes. Now, so what we see on the fee agreement a lot is some fees that should not be listed on the fee agreement. So a lot of times we'll see loan discount points, appraisal fees, the credit report, lender's title insurance, recording fees, prepaid interest, property tax, and the attorney fees. So again, the only fee that should be reflected on the mortgage broker fee agreement is the fee the broker is getting to broker the loan. Lender fees, attorney fees, appraisals should not be reflected on the fee agreement. So in the file, we'll also look at all of the loan estimates. If there's a change of circumstance, we'll ask that you provide that as well. So you must provide the loan estimate to the borrower within 3 days of the application when you have the following information. So once you have the borrower's name, the income, the social security number, the address of the property, the estimate of the value of the property, then you have to send out the loan estimate and also the loan amount as well. Once you have those, once you obtain that data from the borrower, you have to send out the loan estimates. So also in the file, this is another state disclosure that's required. And this is the signed attorney insurance preference form with the list of attorneys if applicable. Section 3710-102 just talks about the attorney fees and other charges on mortgage loans for personal, family, or household purposes. So to comply with the South Carolina attorney insurance preference disclosure, the creditor has to provide the notice to the borrower of their right to select an attorney and also insurance agent within 3 days of the application. The borrower has to choose their own attorney, and then also whoever that borrower chooses as their attorney needs to be reflected on the closing disclosure at closing. Now, when completing the attorney insurance preference form, all the entries on the attorney insurance preference form should be written in the borrower's handwriting, unless you're using some type of e-signature. So this includes the date, the attorney, and also the insurance provider selections. Now, if the borrower does not have an attorney and/or insurance provider at the time that you deliver the attorney insurance form to the borrower, they can enter a TBD, to be determined, undecided, will decide later, but they have to complete something in that section. Now, when they decide who they want to use as an attorney, it's in the best interest to complete a new attorney insurance selection, have the borrower fill out the form, the attorney insurance agent preference form. So that way you'll have two attorney insurance preference forms in the file, one with the to be determined, and then one where the borrower has selected an attorney. And all of this has to be done prior to the loan closing. And if the borrower decides to change attorneys, you may want to have some notes in there on why they decided to change attorneys. All right, so next we'll talk about the closing disclosure. The closing disclosure must be provided to the borrower at least 3 business days prior to the consummation. The lender paid compensation or the borrower paid compensation must reflect the same dollar amount as disclosed on the South Carolina mortgage broker fee agreement. The closing attorney selected by the borrower reflected on the South Carolina attorney insurance preference form should also be reflected as a closing attorney for the loan. Then we're also asked to see the signed right to rescind on a refinance, the 3-day right to rescission, also known as a cancellation rule, is a legal right that allows the borrowers to cancel certain loans without penalty within 3 days of signing the contract. The right of rescission applies to loans that use a person's home as collateral, including home equity loans, home equity lines of credit, refinancing of existing mortgages with a different lender, federally insured reverse mortgages known as home equity conversion mortgages. In that file, we'll also request that you keep a copy of the check that you received for closing. If there's a wire transfer, we ask that you keep a copy of the wire transfer in that file as well. So for those of you who use third-party processors to process your loans, we'll ask that you keep a copy of the third-party processing invoice in the file as well. So South Carolina Code 405820C says a processor or underwriter who is an independent contractor may not engage in the activities of a processor or underwriter unless the independent contractor maintains a license as provided by rule or regulation pursuant to section 3722-270. So basically, if you are a third-party processor, you have to obtain the same license as a mortgage broker. Now, and this is a federal section here that we'll talk about, and which is part 1026.36F, and this requires that state licensed brokers and lenders, if you're going to use a third-party processor, you have to verify the third-party processor with whom the contract is licensed. So basically, it is your responsibility if you are going to use a third-party processor to find out if they have a license in South Carolina to be a third-party processor. You can confirm any third-party processing company that's licensed in South Carolina by calling our mortgage broker licensing division, or you can confirm the registration license through the NMLS website. Now, so the in-process loan files, there's certain disclosures we'll like for you to keep in your files as well. And these are just the minimums, but the initial loan application, the written cover letter, home ownership counseling disclosure, the South Carolina mortgage broker fee agreement, all loan estimates, and also your attorney insurance preference forms with the list of attorneys if applicable. In some instances, the complete loan file may be requested. So the adverse action file, the least we would want to see in that file is the initial loan application, and then also the notification of the adverse action. Now, so we'll talk about two of the state disclosures that we talked about earlier. Just wanted to point out what are some of the common violations that we see on the mortgage broker fee agreements. So the first one is just not providing the broker fee agreement within 3 days of the application. A lot of times we won't see that fee agreement disclosed until the day of closing. So there again, this is where the cover letter comes into play. If you sent out the fee agreement, but the borrower has not signed it, as long as you have something in the file, a cover letter in the file that shows that you sent out the broker fee agreement within 3 days, that meets the timing requirement of that. Another another issue we see is just not completing the broker fee agreement correctly. So that may include, let's say, if you changed branches or if you changed locations and the address at your new location is still reflecting the prior location. I see that a lot. Also see where you're just not completing the broker fee agreement completely, leaving it blank, leaving some of the disclosures blank. Also, we'll see when you're completing the fee agreement where you're not disclosing the broker fee in a dollar amount. You may disclose it in it as a percentage of the loan amount, but do not include the actual dollar amount that you received for the loan. Let's see. So another thing I see when I'm looking at the files is a lot of times the loan amount may increase or the loan amount may decrease, and you don't redisclose the new South Carolina fee agreement disclosing the increased fees. So if the loan amount was 100,000 and then the loan amount changes to 125 during the process, you have to redisclose a new fee agreement that's going to disclose the increased broker fee that you'll be getting based on the increased loan amount. Let's see. So we'll talk about some of the penalties for the fee agreement if it's not disclosed correctly to the borrower. So if the broker or loan officer violates this provision, the borrower may recover from the mortgage broker or loan originator charged with the violation a penalty in the amount to be determined by the court of not less than $1,500 and not more than $7,500 for each loan transaction. So that's very important that you have the fee agreement completed correctly, and also disclosing the amount of the broker fee that you are going to receive for the loan. So they can also recover fees paid to the borrower, to the mortgage broker for the services rendered for the agreement. So if you did not disclose a if you did not disclose a broker fee and the loan closes, the borrower, you may have to refund the borrower for the broker fee that you received. So if you receive $3,000 to close the loan, then you may have to refund $3,000 back to the borrower for not disclosing a broker fee. Also, actual costs, including attorney fees for enforcing the borrower's rights under the agreement. Now, so some of the violations we see on the other state required document on the attorney insurance preference form is not providing the borrower the preference form within 3 days of the application, not completing the attorney insurance preference form correctly, the borrower not choosing the attorney, and also the attorney changing without the borrower acknowledging the change. So initially, if the borrower chooses a specific attorney, and during the process, the attorney changes, then it's not. So a lot of times I'll see where the broker, they'll say, well, I have an attorney for you. We'll just use this attorney. Well, that's a violation because you did not give the borrower the choice of who they wanted to use as the attorney. So I see that a lot when looking at the files. So there's some violations. If you don't disclose the attorney insurance preference form to the borrower, section 3710-105 just talks about if any of the creditor violates a provision of this chapter, the debtor has a cause of action other than in a class action to recover actual damages, and also a right in an action. Let's see, to recover the persons violating this chapter a penalty in the amount to be determined by the court of not less than $1,500 and not more than $7,500 for any of the transactions. So that was a brief overview of the mortgage log requirements and also some compliance issues that we run into when we're looking through files. All right, well, thank you again for attending the presentation and have a great rest of your day.